All right, let's get into it. If you've got a big essay on certainty of objects coming up, maybe for 25 marks, then this is exactly what you need. We're not just going to rehash the basic rules. No. Think of this as your secret weapon, a coaching session to build an argument that's going to make your essay stand out and really push for those top marks. So here's our game plan. First, we'll look at the standard rules, the ones you find in every single textbook. But then, and this is the important part, we're going to start taking them apart piece by piece, digging into the key cases. We'll expose some myths, find out what's really going on, and then we'll build it all back up into one powerful, sharp argument that you can use to structure a brilliant essay. Okay, so every great argument needs something to push against, right? An established view that you can challenge. And for us, that's the textbook definition of certainty of objects. Just think of this as the straw man that we're about to go in and completely knock down. Now, have a look at this. It all seems so neat and tidy, doesn't it? For fixed trusts, where everyone's share is set in stone, you need a complete list of every single beneficiary. Sounds simple enough. And for discretionary trusts, where the trustees get to choose, the rule is the any given postulant test. And that's just a really fancy way of saying that for any person who might pop up and claim to be a beneficiary, you have to be able to say for sure, yes, you're in the group, or no, you're not. This is the standard stuff, right? The law you learn in your first few lectures. But here's the twist. And this is where your essay starts to get really, really interesting. What if these nice, clean tests aren't actually as solid as they look? What if, when you dig into the case law, you find out the courts are actually playing a totally different game? This is the question that's going to drive our entire argument. So let's start with discretionary trusts and this supposed any given postulant test. Everyone points to the big case, McPhail v. Dalton, which you'll also see called Baden 1. But if you actually read the judgment closely, something really fascinating jumps out. And boom, here it is. This quote is gold. Lord Wilberforce himself, in the very case that supposedly locks in the AGP test, actually says this. He agrees that a trust should be fine if there's sufficient practical certainty to do what the settler, the person who made the trust, wanted. He didn't say the AGP test was the only way, he just said the tests for different trusts should be similar. Honestly, that's a massive crack in the foundation of the textbook rule. Now let's jump to the sequel, Baden 2. This is when the case went back to the Court of Appeals to be decided. And for your essay, this case is the smoking gun. It's your #1 piece of evidence that the strict AGP test just isn't what the courts are actually doing in practice. So the whole problem in this case came down to one word in the class of beneficiaries, relatives. And that sounds fine, but what does relative actually mean? Is your second cousin a relative? Sure. How about your sixth cousin twice removed? I have no idea. The problem isn't finding the people, it's that the definition itself is fuzzy. It's what we call conceptually uncertain. Now, under a strict textbook application of the AGP test, that should be game over. The trust should fail. So the court was stuck. And you can see how the 3 judges tried to get out of it. First up, you've got Sachs LJ. He tried to fix it by saying, look, it's up to the claimant to prove they're a relative. If you can't, you're out. But as the scholar Francis N. points out, that's a clever trick. It just dodges the real problem of what relative means. Then you have Mega LJ. He basically said, well, if we can find a substantial number of people who are definitely relatives, the trust is fine. But wait a minute. That's not the any given postulant test, is it? That's a totally different rule. And finally, Stamp LJ. He was the only one who really tried to stick to the strict test. But to make it work, he had to pretend relatives just meant next of kin, which is a much smaller group. So you see, to save the trust, the majority had to either bend the rule or break it completely. And this is the knockout punch for your essay. The simple fact that the trust for relatives was found to be valid proves that the strict AGP test isn't the absolute rule everyone thinks it is. The court's decision just doesn't make sense if that rule were actually being applied. The judges basically ignored the rule to get the result they wanted, which shows they care about something more than just doctrinal purity. Okay, so we've poked some serious holes in the AGP test for discretionary trusts. But what about fixed trusts? What about that super strict-sounding complete list test? Well, let's turn our critical eye to that one now. The absolute key to dismantling this idea is getting the difference between 2 types of uncertainty. First, you've got conceptual uncertainty. That's a problem with the words themselves. Like, a trust for my good friends. Who knows what that means? That can be fatal. But then you have evidential uncertainty. Here, the concept is crystal clear. Say, all employees of my company in 1995. The problem is you can't prove who they all are, maybe because the records were lost in a fire. And it turns out the courts are totally fine with that second one. And this is how they do it in the real world. A trust doesn't just fail because you can't find every single person. No way. The trustees go to court, and the court helps out. They can issue something called a re-Benjamin order. This basically gives the trustees permission to share out the money to all the beneficiaries they do know about, and it protects them from being sued later if someone else turns up. So what does that tell you? It tells you that having a literally complete list is not an absolute make or break requirement.
So if the AGP test is shaky and the complete list test isn't absolute, what on earth is the real rule? Well, this is where we bring it all together. This is the core argument for your essay, a single unifying idea that actually explains what the courts are doing.
Let's call it the practical certainty test. This is the brilliant thesis put forward by Francis Eng, and it's the idea that will make your essay shine. The argument is simple. The real question the court asks is not, does this trust tick a doctrinal box? It's, is this trust workable? Is there enough certainty here for us to practically carry out what the person who made this trust wanted? This one idea explains Baden 1. It explains why the trust in Baden 2 survived, and it explains how fixed trusts get distributed without a perfect list. It just works. Okay, let's assemble this into your battle plan. This isn't just a summary. This is a clear step-by-step roadmap to writing a first-class essay that shows you can think critically, not just memorize rules. Right, here is your winning structure. In your intro, set up that straw man, the textbook rules, and then immediately hit them with your thesis that a practical certainty test is a much better way to understand the law. Then you dedicate a section to taking down the AGP test, using all that juicy detail from the Baden 2 judgments. After that, you do the exact same thing for the complete list test, showing how courts use practical tools like re-Benjamin orders to make things work. Then you propose your solution, the practical certainty test, explaining why it makes sense of everything. And finally, you wrap it up with a killer conclusion. The law is pragmatic. It cares more about making a settler's wishes happen than it does about theoretical perfection.
And it all comes down to this one question. This is the heart of your entire essay. Should the law demand absolute, perfect, theoretical certainty, or should it prioritize practical workability? All the evidence we've just gone through points to one answer. Practical workability wins. By arguing this, you're not just reciting law, you're showing the examiner you can really think. Now go write that first-class essay.